Hey peeps, Stossel's lawsuit has recently finished and I was rating a video discussing the end of it. But while I was rating it, I had found that Viva had made a video covering Facebook's motion to dismiss. And I found it would be a shame not to cover his video. I removed my older video discussing Facebook's motion to dismiss as I feel like I can do a better job in discussing this motion in reference to, well, Viva's poor coverage of it, as Viva is a pretty good representation of blatantly misunderstanding this motion. Let us firstly do a recap of John Stossel's case. His court case can be broken down into two claims. We have a normal claim of defamation. This was a result due to Facebook labeling one of Stossel's videos about environmental alarmism as partly false, and the other claim being over the issue of false attribution, as Stossel says that Facebook and Science Feedback, a fact checker, had made the claim that Stossel's video had said, "Forest fires are caused by poor management, not by climate change." This was supposedly related to one of John Stossel's videos about California's forest fires. We're going to jump into Viva's video almost 9 minutes into it, as a lot of it's already stuff we've already recapped, and with a weird section of him praising Stossel by reading his Wikipedia page.
That in Stossel's fire video, Stossel, end quote, claimed that, quote, forest fires are caused by poor management, not by climate change, end quote. A statement that Stossel alleges, quote, he did not make, end quote. Second, Stossel challenges the statement that the alarmism video, quote, had been subjected to a fact check that had determined that the alarmism video contained factual inaccuracies and was partly false, end quote. Now, for what it's worth, the statement that Stossel says he didn't make that Facebook or their fact checkers said he made was in fact a statement that Stossel did not make himself. It was ironically an oversimplified and entirely inaccurate description of John Stossel's video itself.
So we're going to cover this later as more important information relating to this issue comes more to the forefront, and for the fact that Viva never shows how it's an oversimplification or whether Facebook's fact checkers had actually made the claim at all. So we're just going to hold that false attribution claim to the side, as it's going to be more fleshed out in just a bit.
Actual malice. Stossel is a public figure. Quote, a plaintiff may be deemed an all-purpose public figure, end quote, where there is, quote, clear evidence of general fame or notoriety in the community and pervasive involvement in the affairs of society, end quote. The actual malice requirement exists to encourage heartland First Amendment activity, like Facebook's editorial decisions to append third-party fact checks to posts on its platform. Here you have Facebook simultaneously arguing for Section 230 immunity while they violate the First Amendment rights of other people, while simultaneously claiming the protection of First Amendment rights.
It's good to be the king.
Viva here just thought what he said was intelligent, and that he was making a fool of Facebook, as we can see he plays a little clip at the end. The problem is that it's clear that he has no idea what he's talking about. Facebook can't violate your First Amendment right. It's a business, not the government. And yes, Facebook is also protected by the First Amendment. That's not unreasonable. What is not reasonable is Viva discussing American court cases, let alone American politics, if he doesn't understand the First Amendment. He really shouldn't be titling his video "Lawyer Explains" if he fundamentally doesn't understand American laws. I'm not saying Viva here isn't a lawyer, but I am saying that he's putting zero effort into actually understanding our laws. So titling his video "Lawyer Explains" is pointless and kinda misleading. Now we're going to jump slightly ahead about to the 11-minute mark, as at 10 Viva discusses the issue of malice, which he generally gets right for the most part.
First, Meta is alleged only to have superimposed a fact-check label on the fire video describing Climate Feedback's conclusion that the video was, quote, missing context, end quote. Stossel does not claim that label is actionably false, presumably because it is protected opinion. The conclusion that the video was, quote, missing context, end quote, is necessarily a judgment call, one that is, quote, not capable of verification or refutation by means of objective proof, end quote. That is one heck of a convenient privilege to benefit from when you are a third-party fact-checker making third-party fact checks, that the third-party fact check is not capable of verification by objective proof. And it's not just that they're labeling articles or videos as false or missing context, it's that they penalize accounts over it. They impose monetary sanctions based on these third-party fact checks, which are now nothing but statements of opinion that can never be refuted. Facebook is not in the business of protecting the world against misinformation. They are in the business of providing misinformation.
So not only do we not get an explanation from Viva of why an opinion would be protected, instead we get the typical response from him where he's unnecessarily outraged without any legal explanation of why Facebook is wrong, with the cherry on top being the fundamental misunderstanding of Facebook's argument. But before we get to that, I want you to take notice of that ending statement. Viva never alleges what was actually wrong with the article linked, or the statements made, as this does become a common theme with the lawsuit itself. Hopping back, one thing we should touch on is that sometimes a fact may look like a fact, but it isn't actually a fact. It's actually an opinion. And this can be the inverse for, well, opinions. Typically, if it's plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts, the statement is not actionable. And also, statements are less likely to be expressions of fact where the speaker fully discloses all relevant facts. That's because it's viewed more as an interpretation of those set of facts. This first paragraph and the subsequent 3 others are arguments stating that there was no action Meta took with regard to the fire video that amounted to defamation. And to note, Facebook is not being sued for the missing context or the misleading label. So any ridicule for Facebook for making the statement of protected opinion is for folly, as they're not being sued for the missing context label. That's what this whole paragraph was about. Their basis for believing why they weren't being sued for the missing context label, presumably because it's a protected opinion. Viva is critiquing this paragraph while fundamentally at the same time not understanding what he's critiquing, while acting pretty chum about it too. So Viva's poor understanding of this lawsuit actually led me to a pretty funny realization about this case. So we have the missing context label that's associated with a linked article that John Stossel claims attributed to him a statement that he did not make. For the second claim, we have a partly false label, which also has a linked article associated with it, titled, Video Promoted by John Stossel for Earth Day Relies on Incorrect and Misleading Claims About Climate Change. In the first claim, Stossel has no issue with the label, and then in a reversal, Stossel for the second claim has no issue with the article. An article that is directly calling his video incorrect, not just partly false, and that is calling him out numerous times for misinformation. But the big issue Stossel here has is that his video on Facebook was labeled partly false. It's a really weird disconnect. Now, that's not to say that this takes away from the lawsuit itself, but it's certainly an unusual position for it to be in. As by the label's own statements, the reason it was labeled partly false was because of the linked article. I don't know why the lawsuit doesn't include an additional defamation claim for the article, either for some of the callouts in the text itself or the title alone. Incorrect is a lot worse than partly false. It's highly suspect not to include it. One possible idea is, remember when I discussed the idea of what is and what isn't an opinion? If Stossel can get away the partly false label from the article, i.e. the one thing that contained the disclosed facts, and the explanation on why they think he's wrong, he might be able to squeeze through with his defamation case. But even that line of reasoning is a bit suspect, because at the end of the day, he's suing someone because they called his video wrong. Partly wrong at that. The next bit from Viva's reading is also, like Stossel's lawsuit, a bit unusual.
Third, the challenged implication is not defamatory. Defamatory words are those which, quote, expose any person to hatred, contempt, ridicule, or which cause the speaker to be shunned or avoided, end quote. Hey, peeps at Facebook, I don't know exactly how it works there, but when you accuse a respected journalist of having provided false information, information missing context, etc., it causes people to avoid or shun that journalist, not only their colleagues, but the world at large. A journalist has nothing but their integrity, and when you call them a liar, when you accuse them of providing false information, that is defamatory per se, I would argue.
Firstly, as I've covered before, the paragraphs that Viva is going over addresses the false attribution claim. I need to say that because it seems that Viva here doesn't understand what they're arguing against. The argument is not talking about the labeling of the video as false, because that's later in subsection B, nor are they bringing up the missing context label because Facebook isn't being sued for it. That was the whole point of the first paragraph. Facebook is not being sued for the missing context label. For some reason, in Viva's mind, he thinks this is addressing the partly false label, but nowhere does it actually discuss it. Probably because this is subsection A and not subsection B, which actually deals with that issue. Now, if you could guess, Viva here never actually gets to subsection B, which actually discusses the label issue, which is a bit weird because it's less than a page down. It should have been completely apparent to Viva that this paragraph wasn't about the labels. Nowhere in it does it actually discuss them, and in fact, Viva stops reading when it actually gets to what they were really talking about, Science Feedback's article. Science Feedback's description of Stossel's video as including a claim that California's wildfires were caused by forest management does not question Stossel's honesty, credibility, or reputation. Indeed, its description does not mention Stossel at all. It's a bit weird. Viva left out the part where they explicitly state that the article doesn't even mention the guy's name. Seems like a pretty important piece to a defamation case. And yet Viva doesn't even get to it, even though it's a sentence down. Another tidbit that you were likely to miss is that Viva jumped over the second paragraph. He showed his audience the first, and he showed his audience the third, but for some reason he left out the second one. So what does the paragraph say? Well, it points out that Stossel's description of the article is inaccurate, with once again pointing out the fact that the article never attributes a statement to Stossel, a fact we see repeated in paragraph 3, but once again breezed over by Viva. Facebook also notes in the paragraph that Stossel had basically said the statement at issue. Now, as we know before, it's a bit hard to derive contempt or hatred, the necessary things needed for a false attribution claim, if you already made a near equivalent to that statement. I don't know why Viva decides to leave this paragraph out. This is really bad for Stossel's case. The guy has only 2 claims. With the other 2 paragraphs, we saw some shenanigans from Viva, but it could be placed as him not understanding what Facebook was arguing. But with him skipping over paragraph 2 and its contents, it makes it look like Viva's literally cherry-picking the information to make the case look good to his audience. Now let's jump to the conclusion of their video.
Worse still, they are an opinion that cannot be refuted by any objective means. And yet this is what Facebook uses to determine what is information and misinformation. Now, the outcome of this motion, I am not so optimistic because we saw what happened with Candace Owens' lawsuit. Her lawsuit got dismissed, and I have a feeling this lawsuit is going to get dismissed as well. Maybe it will succeed on appeal, but my prediction, unfortunately, is that Facebook is going to succeed on one of their arguments in their motion to dismiss.
First off, Candace Owens' case was really bad. But then again, Viva misrepresented that case also. Funnily enough, they do share the similarity where both plaintiffs lied to the judge about their case, so they do have some similarities. But if you think that Facebook is going to win still, even though you pointed out their supposed absurdities, you should probably explain why. If Facebook's defenses are so absurd, so ridiculous, it's an unusual flip by Viva to then switch over and say, well, I think Facebook's going to win now. Coming back to the present, as we now know, Stossel's suit was definitely not going to win, as he lost it a few months ago. With one of the reasons being that his false attribution claim was literally the worst. Not only did they never attribute the statement that Stossel had made the claim that they did, which is important to a false attribution claim, but also for the fact that he basically made that statement. And add to the fact that the attribution claim could only work in fiction. As the article existed before Stossel's video, meaning science feedback would have to know the future and then willfully choose to disregard those facts and attribute him a statement that he would not make in said future. Now, in my first vid about this lawsuit, I went with time travel. But science feedback also took note of this problem and instead went with clairvoyance. I would have to say that science feedback was actually pretty quick on what the essence of this lawsuit was. Smoke and mirrors. As it was pretty quick to them that Stossel was trying to limit any facts that actually came into the case, especially when it came to the partly false label. Thankfully, the judge was also able to recognize that Stossel's lawsuit, well, wasn't really there. Second, Mr. Stossel does not identify anything in the alarmism article that is linked via the text box and associated with the alarmism video that is a false statement of fact. To the contrary, his complaint contains only the bare and conclusory allegations that the false statements by defendants are provably false because the alarmism video contained no false facts. In other words, Mr. Stossel identifies no false statements of fact in the alarmism article. Now that wraps up John Stossel and Viva's video. Now, Stossel is appealing his court case to the 9th Circuit, but as you can guess, it's probably not going to go anywhere. And like always, thanks for watching, peeps.